We are live.
Good morning. It appears as though it's the time that was noticed and posted for a work session training for Thursday, April the 1st, 2021. And it appears as though it's 10:01 in the Board of Supervisors hearing room. Any item on this agenda is open for discussion. And since this is a meeting that the public is invited to attend, we ask that you not keep your devices muted, and at the appropriate time, we will have questions and get answers at that time. So please do not intervene while the presentation is going on unless that's the will of the presenter. Roll call, District 1.
Good morning, Madam Chair. Crosby is here.
District 2, Supervisor English is here. District 3. Supervisor Judd may be in transit, and so she may join us at some point, but we do have 2 supervisors present. Due to health concerns related to COVID-19, the board has suspended public group access to conference rooms located in county buildings. Members of the public who wish to attend this meeting remotely can call 602-609-7513 or 888-680-6714, conference ID 911-325-316#. If you have trouble accessing this meeting remotely, call 520-432-9200 for direction. Work sessions are a time for county staff to inform and discuss agenda items with the Board of Supervisors, and public comments will not be taken. However, if you have a question regarding the open meeting law, email the clerk of the board at board@cochise.az.gov by 5 p.m. the day before the meeting. And I understand we did not have any questions submitted, Ms. Lemons? Madam Chair,
Madam Chairman, can you hear me? I am here.
Okay, Peggy is with us, so we do have a full board for this. On introductions, we always ask that for the record, that when you are, before you begin to speak, that you identify yourself so that we have you on record. The item for discussion today is a presentation by Mr. Danny Garone, Arizona Ombudsman Citizens Aid Office, on the Arizona Open Meeting Law. Are you on the line, Mr. Garone?
Yes, can everybody hear me?
It's a little fuzzy. Can you speak a little louder or turn up your microphone a bit?
Yeah, hold on. Let me see if I can fix that.
While you're working on that, I want to thank you for being available to give us this presentation, because all of our meetings certainly are dependent on being able to provide this information and follow it. So I want to thank you up front for your willingness to share with us today.
You're welcome. Is there a, do I still sound fuzzy or distant?
No, you're fine now. Thank you.
Okay, I'll try my best to be clear. I tried sharing the PowerPoint. Is that visible to anybody?
Yes, we can see the PowerPoint.
Okay, and if I click the next button, does it move for you? Are we on the second slide? Did anyone see a transition?
No, we're still on the first slide. And I'm sorry, I can't provide you information on how to do that. So I guess we could call IT if it's necessary.
No, I think I'll figure it out if you can just bear with me for a moment. Sorry about this.
And we had to change rooms because the computer didn't work, so we understand. So, okay, we have the second slide now.
Okay, great. I think we're rocking and rolling now. All right. Is everybody ready for me to begin?
Certainly. Go ahead.
All right. So my name is Danny Garone. I'm with the Arizona Ombudsman's Office, and I'm here to present on the open meeting law today. Thanks for having me. Just real quick, what is the Ombudsman's Office? We're a legislative agency, so we're part of the legislature, similar to how the Auditor General is. Our primary function is to investigate complaints against Arizona state agencies, so agencies at the state level, DES, DCS, the medical board, so on and so forth. So if you ever have a constituent that wants to complain about an act of one of those agencies, you can refer them to our office. As far as the public records and the open meeting law go, those two special categories, our authority extends down to the local level as well, so to the counties, municipalities, school districts, special taxing districts. Part of our responsibility with those two areas of law, in addition to investigating complaints, is to educate and provide educational materials to public officials and the public, which is why I'm with you today. Quick, in case you're not familiar with it, what is the open meeting law? Basically, it's a set of some things you must do when having meetings and some things you can't do. It's not the end-all be-all of how you conduct your meetings. You're still going to have your own procedures, parliamentary procedures, so on and so forth. The open meeting law doesn't have all the answers to everything related to your meetings. It's just a set of laws that are set up by the legislature to maximize transparency in government decision-making. So you all work for the public, so the legislature has decided that your decision-making and your decision-making processes are supposed to be open to the public, so the public can see how you deliberate and what decisions you come to. You're not supposed to make decisions in secret or in private. It's only 10 statutes. It's in Title 38 of the Arizona Revised Statutes, so if you haven't read it, I suggest giving it a quick read. It'll probably take you about 10-15 minutes. Who has to comply? Public bodies. So you're going to hear me use that term a lot. Public bodies is who the open meeting law applies to. What is a public body? Well, it's defined by the open meeting law basically as any governmental multi-member decision-making entity. So your boards, your commissions, your councils, so the board of supervisors, if there's a zoning commission in the county, things like that. Those are public bodies. So the members get together, they talk about things, and then they collectively act. That's the basic framework for what constitutes a public body that is subject to the open meeting law. If you ever have a weird in-between case where it's like, is it private, is it public? It kind of seems like maybe some sort of weird hybrid thing. There's an Attorney General opinion from 2007 that lays out some criteria to use to judge whether that is a public body subject to the open meeting law. The definition of public body, interestingly enough, also includes standing, special, advisory, and subcommittees. So not only is your main board of supervisors a public body subject to the open meeting law, but so are your committees. They are themselves public bodies subject to the open meeting law. Advisory and subcommittees are further defined by the open meeting law, basically as any entity, no matter how you designate it, that's officially established by your public body or by the presiding officer of your public body. So if your board says, hey, you three of you, we're going to designate you to work on this task and report back, and we're going to call you a work group. Well, that's still going to qualify as either an advisory or subcommittee subject to the open meeting law because your public body officially created it. So you got to be careful about when smaller portions of your board or people designated by your board get together to talk about and make recommendations, because they're going to have to follow the open meeting law in almost all situations. Common question I get, I just got put on a board or I just got put on a committee. I heard something about the open meeting law. Is there some sort of training or some sort of certification I need in order to comply with the open meeting law? In short, no. The open meeting law has very few criteria in this regard. All the open meeting law specifically requires is that you review Attorney General's office approved materials at least one day before you take your office. Is there a test? Is there any way for them to know you did this? No, but you should do it because otherwise you're more likely to make mistakes and create trouble for yourselves. At the county level, it's supposed to be the clerk of the board that's supposed to provide these materials to you. That usually takes the form of either our office's booklet on the open meeting law or the Attorney General's handbook chapter on the open meeting law. So if you haven't looked at that, I suggest doing that. This is all the open meeting law requires. Your county might have additional requirements above and beyond this, so check with county staff as to whether by county ordinance, you're required to do something more above and beyond this. Who might you hear from as far as a potential open meeting law violation? The main game in town is the Attorney General's office. They have authority to investigate open meeting law matters, and they can take you to court to enforce the open meeting law. They usually don't do that. They usually tell you they're investigating you, and if they think you violated the open meeting law, they usually try to come to some sort of informal agreement, which usually looks like, hey, here's why this was a violation. Don't do it like this. Take the following corrective action, get some training, sign here. If you don't agree and you don't want to do that, then they might take you to court and you might have a little legal fight over it. It's up to you. Additionally, the Attorney General is the only entity in the state that can take you as an individual member of your public body to court for violating the open meeting law. So if they think board member Smith is being extra shady and intentionally violating the open meeting law and they want to make an example out of him or her, they can take that board member to court and ask a judge to basically find they violated the open meeting law and penalize them. Again, the AG is the only entity to do that in the state, and it's very rare. I'm not personally familiar with any recent examples of this. You really have to be operating in blatant disregard of the open meeting law and doing all sorts of shady things in private and just not listening. So try not to worry about this. We all are human. You're going to mess up the open meeting law at some point if you're in government long enough. The key is to recognize when you do, take corrective action, and work not to do it in the future. Additionally, the county attorneys can enforce it. I don't think they do that too proactively. So if your board's meeting in secret or something, they can take you to court to get a judge to say, here's what you have to do. And then last, any affected party, so any random member of the public, basically, probably can take you to court to enforce the open meeting law. So if you're violating it, they can sue a court to order you, sue you in court and ask the court to order you to comply with the open meeting law. And then last, you might hear from us. We don't have enforcement authority, but we do have very broad investigative authority. You got to talk to us. You got to provide records, so on and so forth. And then potentially we can write a public report on what you're doing wrong if we think you're violating the open meeting law. We pretty much never do that. We try to resolve things informally, but when push comes to shove, we can produce that report. So if you hear from me, it's going to be an informal context, probably to find out, hey, what's going on? I heard from the complainant and I want to hear your side. And then let's see if we can fix this if I think you are violating the open meeting law. So what do you have to do? What does the open meeting law require? This is probably the most important slide I'll show you today. It really outlines the 6 basic requirements of the open meeting law. I'll get into the specifics as we go, but if you remember anything, remember that this slide exists. So in order to comply with the open meeting law, you have to provide notice when you're going to have meetings. You need to have an agenda for your meetings. You need to meet in public and allow the public to attend. You need to take all action. So all collective decisions must take place in public. And then you either need to have written minutes or recording of all your meetings. That's the bread and butter. Before I jump into those, it's really helpful to know what we mean when we say meeting. In the regular world, we have an idea of what the word meeting means. But of course, the legislature has created a legal meaning for it, a legal definition for meeting in the open meeting law. And that's defined basically in a 2-pronged way as the gathering of a quorum to either discuss, propose, deliberate, or take legal action. So you need to have a quorum present, and you need to basically be discussing or acting on anything that could reasonably and foreseeably come before your board for action. So if you don't have a quorum present, you probably don't have to comply with the open meeting law because you're not having a meeting. If you have a quorum present, but you're discussing baseball or just making small talk about nothing important, you probably haven't triggered the open meeting law. You're not having a meeting. So whether you're having a meeting, so whether you're meeting these 2 prongs, will be the answer to a lot of open meeting law questions. The definition was altered, basically augmented a couple of years ago by the legislature to include the following language on this slide. It seems like a lot, but it's really intuitive in light of the other the definition on the previous slide. I think this stuff right here was probably already incorporated into what was on the previous slide, but for whatever reason, the legislature decided to make it very clear that this type of activity also constitutes a meeting. So if you have a one-way electronic communication where you propose legal action to a quorum, so if I'm a board member and I write an email to the rest of my board and say, I want to take the following action at the next meeting. That constitutes a meeting. That's proposing legal action amongst a quorum. That's a violation. Similarly, a multi-way exchange amongst a quorum. So basically, if you have a discussion or deliberation by electronic means outside of a proper meeting, that's also a violation of the open meeting law. So if I email my board and say, here's what I'm thinking on this one issue, and then somebody hits reply all, so the whole board saw multi-way discussion, that would trigger the open meeting law, and that would be a violation. A quorum is the minimum number of people for a public body that needs to be present in order to officially conduct business. So if you have a board with 9 guys on it, if you have 2 of them bump into each other at the grocery store, they can't make decisions on behalf of the entire board. There's a minimum number that need to be present. And that's usually a simple majority in the state of Arizona. So if you have 5 members, a quorum is 3. So 3 allow you to conduct business, and that's also the thing that triggers the open meeting law. Based on the total number of seats on your public body or the total number of people who have been appointed to the seats. So if you have 7 spots on your board, but only 5 are taken, is the quorum based on the 7 or the 5? The open meeting law is not clear, and I don't think Arizona law in general is clear about this. So I suggest being conservative and base it on the total number of seats. So have the higher requirement. I think that's less likely to run you into trouble going forward. And just be conservative about it. That's my recommendation. The open meeting law says, as you might have seen on that previous slide, a meeting is when you're gathered in person or through remote means. So that sort of implies that you can have use electronic communications to conduct a meeting. So you can have telephone conferencing. So if you want to have a conference call, as long as the public can attend, that's fine. In the age of the coronavirus, I think everyone has really leaned on electronic communications to conduct their meetings. We're doing it right now. As far as I read the open meeting law, that's good. No issue with that. And I think the Attorney General agrees with that. If you are going to, especially in the future when you get back to in-person meetings, if you're going to have one or several of your members attend remotely, say you're going to have a speakerphone set up in the room, I suggest putting that in the minutes or the recording so everybody knows what the deal was. And also make sure everybody can hear everybody. The first major requirement on that important slide earlier is what's known as the initial notice or disclosure statement. This is something that you perpetually have posted that tells the public where your meeting notices will be. At the county level, you must have this posted on your public body's website. There are some exceptions for certain municipalities and special taxing districts, but they don't apply to you guys. So the county must have something on its website that says, for meetings of the County Board of Supervisors, notices will be posted at the following locations. Something along those lines. And that needs to be pretty easy for the public to find that statement. You can alter that statement as time goes on, but you must have it posted. So to piggyback off that, every time you want to meet, you need to have a notice for the meeting. So for this meeting you're having right now, there should have been a public notice posted 24 hours in advance, available to all members of the public, to all members of the public body, so on and so forth. It needs to be, again, posted 24 hours in advance. The 24-hour notice period can include Saturdays if all the places you post your notice are open to the public on Saturday. So if you post it in a government building that's locked on Saturdays, then Saturdays don't count. Sundays and holidays also do not count. There are some small exceptions to the 24-hour notice requirement, and I'll get into those in a minute. So what does your meeting notice have to have? Who's meeting? So which public body is it? Is it the Cochise County Board of Supervisors? Well, then write that on the notice. Is it a specific committee? Then write that on the notice. The date, time, and place. Where and when are you meeting? Be as specific as you can be, especially on the location, so people can find where that is. If it's going to be all electronic, then be as specific and clear as possible how the public can attend it. And then last, your notice has to have an agenda, or it needs to tell the public how they can get the agenda. I think it's most common now to either post the notice and agenda together or to make it one document. So the public just finds your notice and they also have the agenda. But you don't have to do it like that. Your notice can say something along the lines of email the clerk of the board at this email address if you're interested in a copy of the agenda. That would be fine as well. That's going to create more work for you. It's probably going to agitate the public because they're going to say, why isn't the agenda posted? So I even though it's not required by law, I do recommend posting your agenda similarly to how you would post your notice, or to just make it one document. But it's up to you. Post your notices in all the locations you said you would in your disclosure statement. So you have the statement on your website that says, here's where we'll post all of our meeting notices. Well, when you want to have a meeting, you got to post notice in all of those locations. You can post it in even more locations if you want, but not fewer. You must post it on your website. There's an exception again for special taxing districts, but it doesn't apply to you guys at the county level. So every time you have a meeting, 24 hours in advance or more on your website, you must post the notice for the meeting. And then you also must give whatever other notice is reasonable and practicable. What does that mean? I don't know. The legislature didn't say. So we know you must post on your website. Do you have to post somewhere physically as well? It's not clear that you do, but I would suggest posting in at least one physical location. I think that's how most public bodies have interpreted the reasonable and practicable language is, okay, we'll post it online as we're required to, and then we'll post in at least one physical location. Some hopefully common sense tips on posting your notices. I know it's probably not going to be the board doing it, but board staff. But just so you know, and just so any staff listening, especially if they're new, make sure it can't easily be removed. So if you're just going to scotch tape it to the outside of a brick building on a windy day, probably not going to cut it. It's going to blow away or get torn down by somebody. If the pages have text on the back of them, say you're posting it in a physical location and it's front and back, make sure people can read the back. And then another tip, which I would suggest whoever routinely posts your notices, get into a regular practice of how you do it and about when you do it as best you can, because that provides some evidence that you did post it if challenged. And then also I suggest either initialing or signing with a timestamp for when you do post the notice. That way, if someone says, hey, your notice wasn't posted in time, you have some evidence to show that it was. It's a way of protecting you, even though it's not required by the open meeting law. So I mentioned there are two exceptions to the 24-hour notice requirement. The first one is you can recess and resume a meeting. What does that look like? Well, you have your proper meeting. So you've created a notice, you've posted it 24 hours in advance, and you're starting your meeting. But the meeting's dragging on forever and you need to take a break. You can tell the public, all right, we're going to take a 1-hour recess. We'll resume the meeting in about 1 hour, same place, same location. And then in an hour, you can resume the meeting without creating a new notice, without creating a new agenda, without a new 24-hour notice period. Can you recess and resume the meetings on a later date? So if you want to do it 48 hours later, there's nothing specifically in law that says you can't do that. But I think this was really intended to be like a less than 24 hours thing, because if it's longer than 24 hours, you can then just post a new notice and a new agenda so that the public knows what's happening. I think this is really just a way to tell the people who are already in attendance, hey, we're going to take a break. We'll be back at this time, this location. So if you're going to go longer than 24 hours, I suggest just doing a new notice and agenda. Second exception is for emergency meetings. If you have an actual emergency that necessitates meeting in less than 24 hours, then you can do so. What is an actual emergency? I think it's really a situation where if you don't act due to unforeseen circumstances, there's a serious threat to life, limb, or property. Buildings will burn down or flood, people will die or be hurt, that type of thing. And it requires you to act to hopefully avoid or reduce the danger of whatever that is. Great example, coronavirus. Hey, there's this new plague, March 2020, there's this new plague rolling around. How dangerous is it? What do we need to do to protect the public? That's the type of thing that you can justify an emergency meeting for. So if Do have an emergency like that, what do you need to do? Well, you don't need to do the 24 hours of notice. Obviously, that's the whole point. But do provide notice as soon as you can. So if you got 4 hours to spare before the emergency meeting, give 4 hours of notice and publicly announce the reason for the emergency meeting. So what's the emergency? Put that in your minutes or in your recording so anyone who didn't attend, they'll know what the heck the emergency was. And then after the fact, within 24 hours after the meeting, post like a notice agenda like you normally would ahead of time explaining that the meeting happened, because sometimes people won't notice that the emergency meeting happened. This is a way of telling everyone, hey, if you missed it, we had an emergency meeting for these reasons. Super common question, especially on a smaller board. I think, did I hear you right that you only have 3 board members?
That's correct.
Well, then it's probably even more likely this will happen to you. So people call me up and say, hey, a bunch of us on the board might be at the same place at the same time for some sort of social event. There's some sort of rally or dinner or a political event, and 2 of your 3 board members are going to show up. So a quorum is going to be there, but you're not going to do anything official. Do you still have to follow the open meeting law? The answer is no. If you remember back to the definition of meeting, you need a quorum present and you need to be discussing, deliberating, acting on official business. So if you're going to be on best behavior and not discuss any county business or anything that could become county business, then you're fine. You're not having a meeting. You don't need to comply with the open meeting law. But you got to remember to stay on your best behavior. It's very easy to start talking about official business. So be careful not to do that with a quorum of your board. So you don't have to follow the open meeting law in these situations. But I'd still recommend posting what's known as a courtesy notice or a courtesy agenda. Something you post like you normally would for a meeting that says something along the lines of a quorum of the Cochise County Board of Supervisors might gather at this time in this place. It's purely a social event. No official business will be transacted. This is being issued purely as a courtesy. That way, if somebody bumps into you and goes, oh, the board's here, what's going on? They don't think you're up to no good. You were transparent. You told everybody it was going to happen. There doesn't need to be panic over secret board meetings. You don't have to do this, but I suggest you do it. It reduces the likelihood of causing complaints amongst your constituents. But again, you got to be careful and stay on best behavior for what you talk about. The third major requirement under the open meeting law is the agenda. I think everyone has at least an idea of what a meeting agenda is from past experience. Basically, this is the written roadmap for what's going to be talked about and decided or possibly acted upon at your meetings. Everything you're going to do at your meeting needs to be specifically listed on the agenda. It needs to be reasonably specific enough that a member of the public can read it, get an idea of what's going to happen, and decide if they want to be there. I always think, is this specific enough that my mom, who has no idea what's going on with this public body, would understand, at least get the basics of, and decide if she wanted to go? If not, it's probably not specific enough. So err on the side of specificity. And then everything that is discussed at a meeting needs to be reasonably related to a specific agenda item. If I'm hearing your discussion and I can't figure out which agenda item it's related to, it just seems so far afield, then it's not something you should be talking about at the meeting. It needs to be reasonably related to an agenda item. Issues that come up with agendas, using language the general public doesn't understand. In government, we have so much law, so many acronyms, so much jargon that the general public probably doesn't know. Avoid using that stuff in your agenda, or if you're going to use it, explain what it means so the public understands what you're doing. Otherwise, you're not really providing notice if the public can't understand your agendas. Same thing with using vague or ambiguous terms. Avoid agenda items that are so vague that nobody knows what you're talking about. So writing that the board's going to discuss new business or reports or manager reports, what does that mean? Nobody knows. What manager reports? What information? Be specific. So if you want to use those general terms, fine, but then you need more specific explanations below them. So if you're going to write new business, then there should be bullet points or additional sentences below that explain what items of new business. One kind of exception to that, and that's providing a brief summary of current events. You can put on your agenda that one of your people is going on your board is going to provide a brief summary of current events without listing all of those current events. So then at the meeting, the board member can stand up and give you the brief summary, say, hey, the deadline for this is on Wednesday, and the results of such and such event were this, and blah, blah, blah. And then they can sit back down. And there's no further discussion. If you want there to be any further discussion on any of those items, then it needs to be its own specific agenda item. One of the cardinal rules of the open meeting law, if it's not on the agenda, you cannot talk about it, you cannot act on it, you cannot vote on it. Even if it's a really important thing that you're kicking yourself for not putting on the agenda, too bad. If it wasn't on the agenda 24 hours in advance, do not talk about it, save it for a future meeting. Be reasonable about where and when your meetings happen. Once we get back to real life and we meet in person, it has to be in a place the board can, or the public can attend. So if it's in a members only club or in a member's house, unless you got a way for all the public who wants to attend, it's not going to comply with the open meeting law. If you have your meeting in a big hall, don't sit at the front and whisper so nobody can hear you. If you know 50 people want to show up, don't intentionally hold your meeting in a broom closet so no one can fit and attend the meeting. Don't have your meetings at 3 a.m. Sunday morning. You got to be reasonable and allow the public a reasonable ability to attend your meetings. Another super common question. I get this from the public and I get this from government officials. What does the public have a right to do at these meetings? Generally, under the open meeting law, the public only has a right to show up, listen, and record the meetings. They do not generally have a right to participate in the meetings. You can give them a right to participate, or depending on the type of meeting and the type of content, maybe some other area of law provides some sort of right for the public to participate, such as for a zoning hearing or something. But generally, under the open meeting law, the public does not have a right to speak or disrupt your meetings. So what happens if the public insists they do have a right to speak at your meetings? They pound the table and they shout, "This is a democracy. That means I get to shout at you and tell you how unhappy I am with you at your meetings and weigh in on the topics." And they just continue to disrupt the meeting. Well, I suggest warning them a couple times on the record. Hey, you can't talk. I'm sorry. You'll have your opportunity later, or put it into an email or call to our offices. This is not the time and place for this. And if they just refuse to cooperate after warnings, then you can do what you need to do to remove them. You can ask the sheriff or security or whoever to remove them. I suggest that's a last resort because they can and might sue you under the First Amendment or what have you. And even though you'll probably win, it's going to be a headache. So I would suggest removing someone a last resort. But you can do it, and sometimes you probably will have to. With all the coronavirus stuff and people with very strong opinions on closings and masks and stuff, that I'm sure you've had some very heated public participation. So generally the public doesn't have a right to speak at your meetings, but you can still give them the ability to. This usually takes the form of what's known as an open call to the public. Again, it's optional unless somewhere else in law requires it in a particular situation. It has to be on the agenda, so you can't just do this willy-nilly. It needs to be an agenda item. You can subject speakers to reasonable time, manner, place restrictions. That comes out of First Amendment law, so don't discriminate based on viewpoint or content. That's an easy way to get sued under First Amendment law. So treat everyone equally. So if someone wants to talk about stuff that you don't like, too bad. If they want to say mean things about you, too bad. If they want to trash other people, probably too bad. Just let it go. The First Amendment's very powerful. And once you open the floor to public participation, you'll lose a lot of power to restrict what's happening. The Attorney General thinks you can ban repetition. So if you know there are going to be 100 people on the same side of an issue speaking at a call to the public, according to the AG who looked at what's happened in other states, you can say, okay, we're only going to take the first 5 on either side, or you guys get together and nominate 5 speakers. We don't have time for all 100 of you. There's no reason to believe that that's okay under Arizona law, so I would suggest avoiding that if at all possible. Either don't have a call to the public or let everyone who wants to speak for their whatever amount of minutes. Whatever restrictions you're going to subject the public to, so you can give everyone 3 minutes or something, I suggest making that known ahead of time and strictly adhering to it for everyone. So if you're going to cut the first person off at 3 minutes, don't let the next person go 5 minutes. That's a good way to create a ruckus and maybe get sued. Some things to avoid or watch out for when it comes to calls to the public. The public can talk about things that are not on the agenda for the meeting. You, however, are still limited to only what's on the agenda. So if a member of the public brings up an item that's not on the agenda, you don't suddenly acquire the ability to talk about it and act on it. You're still bound by your own agenda. So what happens in that situation? They bring up the budget, which is not on the agenda. Well, you can ask your staff to study the issue or ask that it be placed on a future agenda. That's it. And if they make criticisms toward you, you can respond to those criticisms. So if a board member or a member of the public stands up and says, Board Member Garone, your tenure has been garbage and here's 2 minutes of why. If I want, at the end of the call to the public, I can reply to that criticism. I don't have to, and I probably would recommend you don't, because then it's going to entice the public to get into to think this is now a debate, which it's not. But you can do that. You can respond to criticism. But that doesn't allow the other board members to then chime in and discuss it. Respond directly to the criticism, and then it's over. Some things to avoid at your meetings. They may or may not be violations depending on what you specifically do, but at a minimum, they're barking up the wrong tree. You're looking for trouble. Passing notes, whispering, texting, emailing each other back and forth during the meeting. So if you lean, especially on a 3-person board, if you lean to the person next to you and start whispering, that looks like you're having a secret discussion that's in violation of the open meeting law. And if you're talking about official business, it probably is. If you're talking about where to go for lunch, it's not a violation of the open meeting law because it's not related to county activity, but it's suspicious and will cause you trouble. So I suggest avoiding that type of stuff as much as possible. Then additionally, be careful about accidentally forming a quorum before or after your meeting. Say your meeting ends at 5 p.m., you're walking out to the car, a constituent flags you down and wants to talk about stuff. That's fine, you can talk to them all day long. But then if another board member wanders on over because the conversation sounds interesting and all of a sudden you have a quorum standing there talking about board business, you're violating the open meeting law. You said the meeting was over at 5, now it's 5:30 and you're out in the parking lot with a quorum talking more about it. You got to avoid that type of stuff. So I just gave you, 30 minutes about how you need to be open and transparent. Now I'm going to tell you about some limited situations where you get to exclude the public from your discussions. These are called executive sessions. You have to tell the public they're happening, but then your discussions and what you actually say is private, and you not only does the public not get to hear it, you're not allowed to tell them. Now I need to update this slide. There are now 9 types of executive sessions. They're listed in ARS 38-43103, A1 through 9. The subsections 1 through 9 list the 9 different types of executive sessions. Those are the only situations that you can have these executive sessions. If it doesn't fit neatly into one of those 9, don't do it. You have to have the discussion in public. So if you want to have an executive session, you have a topic that fits one of the 9 categories, what do you need to do? Well, you need to either have a notice and agenda for it that's made available to the public, or it needs to be part of an already pre-existing notice and agenda. The most common way to have an executive session is you're already having a public meeting, and then at one point in the meeting, you're going to either go into a different room for an executive session or you're going to kick the public out. So part of the meeting is going to be an executive session. That's fine. That's great. Just make sure it's on the agenda and notice. Alternatively, you can have a standalone executive session. In that case, you need to have a separate notice and agenda for it, just like you would a normal public meeting. You need to have a public vote to go into executive session. So if you want to go into executive session, you need to have your motion and vote, and a majority or whatever needs to vote in favor of having the executive session. then you can have it. All this, once you go into executive session, all discussion must remain confidential. Do not tell anyone who was not in the meeting what other people or what you said in executive session. Do not take action. So do not make decisions in executive session. Do not vote to spend money. Do not vote to fire people. Do not vote to rename something. All of those actions must take place in public. So there will be situations where you can discuss something in executive session in private, but then to actually decide and act on something, that must take place in public. So you got to come back out into public to take the vote, and you got to be clear about what you're voting on. And then last, even though they're confidential, you must have minutes or a recording for your executive sessions. And I'll explain why in a moment. So there are a lot of situations where you could have an executive session lawfully, but you don't have to. So it's up to you to decide whether it's worth the trouble. Is the increased public suspicion you're going to face from going into private worth whatever the benefit is that you're getting from it? That's for you to weigh. So according to the open meeting law, the notice for the executive session or the notice agenda that says there will be an executive session must include the specific statutory provision authorizing that executive session. So there's 9 subsections in the statute. You need to cite the statute and which subsection enables that particular executive session. And then your agenda must list a general description of what you're going to discuss or consider in executive session. It needs to be more than just simply citing the statute and saying, pursuant to the statute, we're going to have an executive session for legal advice. You got to be a little more specific than that. But you don't have to be so specific that it defeats the whole purpose of the executive session or reveals protected information. So you got to kind of walk a somewhat fine line there. Who gets to be there in executive session? Members of your board. So whatever public body's meeting in executive session, all the members get to be there. If you're having a personnel discussion, which is one of the 9 types, there's nothing that prohibits you from allowing that person to be there that you're talking about, but they're not specifically required to be there or entitled to be there. The Auditor General, and then any other individuals whose presence is reasonably necessary to carry out the executive session. So you want to have your lawyer there to give legal advice, that's fine. You want to have a clerk or a staff member there to run the video camera or to take written minutes, that's fine. You want to have your friend Bill down the street there so he can just see how it goes, and he's always wanted to see what an executive session's like. That's not going to fly. The person needs to have a good reason to be there. If you're going to have any unusual people be there, so anyone besides like the clerk, attorney, and the board, I suggest putting down in the minutes or in the recording who that person is and why they're going to be there, and maybe even put that in your agenda as well, just for transparency's sake. What are some issues that come up with executive sessions? Revealing what was said in executive session. Do not tell people what was said in executive session. That's a violation of the open meeting law. The open meeting law specifically requires your chair, the chair of your public body, to remind everybody prior to each executive session that it's confidential and not to reveal what was said. And then second, again, do not take legal action in executive session. Legal action is defined as any collective decision made by your public body. So if you're deciding to do things, to spend money, to take certain actions, that needs to be done in public. So real quick, I'll run through the types of executive session. The first one's for personnel discussion. So if you want to discuss whether to fire, hire, promote, demote, give a salary raise to, so on and so forth, an employee of your public body, you can have that discussion in executive session. It needs to be an identifiable individual. So if you have 100 employees and you just want to discuss whether to give an across-the-board 3% raise, you can't do that in executive session. But if you want to talk about whether to give 2 particular employees a raise, you can do those discussions in executive session. This type of executive session is special. It has additional requirements above and beyond what the normal is. In addition to your normal notice and agenda, you need to provide specific written notice to the person you're going to discuss their employment 24 hours in advance. So if you're going to discuss whether to give a bonus to one of your employees, Not that that happens in government world, but you know what I'm saying. You need to give that person something in writing 24 hours in advance that says, hey, we might discuss your employment in executive session at, such time and such place. That person, assuming the discussion isn't about salary, has the right to ask, to require that discussion be held in public. So they can basically veto the executive session discussion about themselves if it's not about salary. So if they respond back to your notice and say, oh, you want to talk about whether to fire me in executive session? Too bad, do it in public. Well, then you either need to do it in public or not do it at all. And then again, nothing in the open meeting law gives that person a right to be there for the executive session, but you can allow them to be there. And then either way, they're going to get access to the minutes or the recording of the executive session discussion about their employment. A couple questions related to this that have come up that the AG has addressed. Can you do personnel evaluations in executive session? The Attorney General says yes. I think that's reasonable. Can you interview applicants for a position in executive session? Again, the AG says yes. I think that's reasonable, so go ahead. And I think the courts have backed that last one up too. The second type of executive sessions for confidential information. So if you have information that's protected by state or federal law that you can't reveal to the public and you need to talk about it, this is how you do it in this type of executive session. Third, and probably most common, is legal advice. We've all heard of attorney-client privilege. That means discussions between an attorney and their client about legal advice and legal counsel are protected by law and don't have to be revealed. The same thing exists between a board and its lawyer. So in order to protect that privilege, you can have your legal advice rendered in an executive session. So you can go into executive session and say, hey, attorney, here's the issue. Here are our questions. Here's the relevant information. What do you think from a legal perspective? And they can render legal advice. And you can go back and forth with legal questions and additional information so that you can keep getting legal advice. But once you want to decide what to do with that legal advice, so the board says, thanks, attorney. And then the board says, okay, guys, what do we want to do with this? That's a discussion that needs to happen in public or in a different type of executive session. You can't do it in this one. You can't start debating the pros and cons or the policy of what to do with the legal advice. Or at least you can't do it in this type of executive session. And then real quick, here are 4 less common ones. You can go into executive session to discuss and consult with your attorneys about litigation, contract negotiations, settlements, and you can tell your attorney, to go operate on your behalf. Go see if they'll settle, go see if they'll negotiate up to this point, so on and so forth. But then if you actually want to settle or sue or sign a contract, you have to take a public vote on it. The next one, if you're negotiating or consulting with an employee organization about salary, so basically if you're negotiating with a union over salary, you can talk with your own board and your own representatives about your negotiating position in executive session. You can't do the negotiating in executive session. Then there's an exception or an executive session for international, interstate, and some tribal negotiations. Again, you can talk about your negotiating position amongst yourselves in executive session. And then last, again, similarly, if you're buying, selling, leasing real property, you can talk about your negotiating position in executive session. All of these are basically set up, these 4, to protect your negotiating position. So your adversary or your opponent in whatever the issue is doesn't know what your negotiating position is, and therefore weaken your hand. Last year, the legislature added 2 more, which you may or may not be aware of. They're very similar. One's limited to schools. One of them is expanded more broadly. The first is you can go into executive session to discuss or consider school safety operations. So if you want to come up with school shooter drills or whatever and procedures, and you don't want possible school shooters to know what they are, you can have the discussions in executive session. And then similarly, a public body can go into executive session and with representatives to discuss security plans and procedures and similar stuff to protect your buildings and your people and your infrastructure and so on and so forth. So again, same concept. We want to discuss safety procedures, but we don't want the people who might be committing the violence or whatever to know what they are. So you can do it in executive session. And it also makes all related records exempt from disclosure under the public records law. These both went into effect in the last year. The last major requirement under the open meeting law is minutes or recording. So for every meeting, you need to have written minutes or recording. Some public bodies will create a recording initially and then use that to then write up written minutes. If you choose to do that, you can't get rid of the recording as soon as you're done with it. So you create the written minutes and you want to delete the recording. According to the state, you got to hold on to it for 3 months. So don't just shred that recording. Otherwise, whichever one's going to be your official record, your minutes or your recording, is a permanent record that needs to be kept forever. What do these minutes or these recordings have to have? Which public body met, and then where and when? Which of your members was there, which were absent? General description of everything you talked about and considered. An accurate description, so a specific, accurate description of all legal actions proposed, discussed, or taken. So anytime someone proposes to take an action, your minutes need to accurately describe what they proposed. And then somewhat recently, the legislature required that you now need to have a record of how each member votes for every vote. So if you have 3 members, every time there's a vote, I should be able to read your minutes or watch or listen to your recording and know exactly how each one of the 3 of you voted. Question I get all the time is, well, if it's unanimous, do we need to write down each person's name? No, as long as you're indicating that all 3 of you were present or that 2 of you were present by name, so I know who was there, and then you say it was unanimous, and it truly was unanimous, then that's probably good enough. But if you want to be better safe than sorry, for each vote, write down the 3 names of your 3 board members and how they voted. You also need the names of everybody each member who proposes each motion, the name of each person as given to whoever makes statements to the board. So if you bring in somebody to testify or a member of the public talks, you need to write down their name as they give it to you. So if they give you a fake name, they say Mickey Mouse, well, you can probably just write that down and that's fine. And then last, what were they talking about? Which agenda item was it in reference to? So if it was just general call to the public stuff, then indicate them in the call to the public section. And that's it. Something to be aware of if you're going to do an audio or video recording, be cognizant that not everybody knows who you are by your face or by your voice. So identify who's speaking, identify who's voting, so that the public knows who's doing what. And that's it. That's what your minutes or your recording need to contain. Common question. Hey, I want to get my hands on the minutes, or I want to get my hands on the recording. How do I do that? Am I entitled to that? The answer is yes. The public is entitled to those. Those are public records subject to disclosure under both the open meeting and public records law. The open meeting law says within 3 days, 3 working days after the meeting takes place, you must have minutes or a recording available with all of this stuff to whoever wants to see it. So if the meeting is Monday and on Thursday, somebody says, hey, let me get the minutes or let me see the recording, you need to have something ready to give to them. You do not get to make them wait until you formally approve it. 3 days later, you can write down draft or unapproved, but you got to have it ready for them. There's some additional requirements that only apply to cities and towns over a certain population. I'm not going to get into it, but just generally, in addition to all the minutes requirements, cities and towns over 2,500 people also have to post summaries of legal actions taken or recordings of the meeting online within 3 days. And then once they're approved, you gotta keep them up there for a year. Doesn't apply to counties. There's a semi-new meeting requirement. It's not in the open meeting law, but it deals with meetings that applies to licensing authorities in the state. So it doesn't apply to you guys, but I bring it up because I think it might get expanded to apply to everybody at some point in the future. Basically, licensing authorities now need to record their meetings and make those available and post them online. Doesn't apply to you guys yet. You don't have to post your minutes or your recordings online, but I think at some point in the next few years, it's probably going to change. So if you don't record your meetings and you don't post them, but you've been thinking of doing that, might be better to just pull that Band-Aid off now and get in the groove before it becomes a requirement and gets thrust on you by the legislature. I mentioned that even though they're confidential, you must have minutes or recordings for your executive sessions as well. You got to keep these confidential. The public does not get to see these, but you still need to have them. Why? Well, one, you guys might want to refer to them at some point in the future so you remember what happened. And two, if you get sued, if somebody says, I think you're having illegal executive sessions, you're going to bear the burden of proof in court of showing that your executive session was legitimate, and having minutes or recording is how you can do that. So what do these executive session minutes or recordings need to have? Same type of stuff. Which public body, which members were there and which weren't, when and where did you meet, what did you talk about? If you give instructions to a lawyer or representative in regard to negotiations, accurately describe those instructions, and then whatever else you think is necessary. Keep them confidential. Separate them out from the public portion of your minutes and do not let the public see them. So who does get to see them? Members of the public body. So if the 3 members of the board meet, the board members get to see the executive session minutes. If you talk about one of your employees in executive session, they get to see the minutes or the recording, at least as it pertains to their employment. The Auditor General, and then any oversight agency. So the county attorney, AG, the ombudsman, the courts, they can all see executive session minutes or recordings. If you ever find yourself trying to be sneaky and resourceful and clever for getting around the open meeting law, you're probably violating the open meeting law. It's not a set of challenges to be overcome. It's a set of transparency laws that you're supposed to comply with. So you can't get around the open meeting law by using a device or some electronic means. You can't do what's known as splintering the quorum, which is basically a fancy game of telephone. If you guys, you can't do anything because you have three board members. So the second one of you starts talking to another one about official business, you've triggered the open meeting law. But if you had a bigger board, you might do what's known as splintering the quorum, which is one board member emails another, and then that person emails a third, and it becomes a game of telephone. So even though it didn't happen simultaneously, it reached a quorum about official business. That's probably a meeting and a violation of the open meeting law. Similarly, don't poll each other. So don't shoot an email to the other 2 members saying, hey, how are you going to vote at the next meeting? If they respond, that's probably a violation of the open meeting law. It doesn't have to be verbal. You can violate the open meeting law in writing, emails, letters, so on and so forth. And also, it doesn't need to be simultaneous. So if I send an email to the rest of my board saying, hey, what do you think on this issue? And then the next day they reply, it's still going to be a violation. AG opinion from 05 that says you can't get around the open meeting law with email. So if you have a quorum on the email, if you send an email to a quorum that proposes legal action, you're violating the open meeting law. If you have a multi-way discussion through email amongst a quorum where you discuss, deliberate, or take action through email, you're violating the open meeting law. Same thing goes for other electronic communications, Twitter, direct messages on Instagram or Snapchat or any other new app. You can violate the open meeting law using those as well. Say you have a 5-member board, so the quorum is 3. 3 is what triggers the open meeting law. Imagine one member sends an email to 2 of the others, so it reaches a quorum, and then one of those other ones hits reply all. If that's about anything related to what you do as a board member, so it's not just about like the Diamondbacks, it's about official board business or something that could become board business, then that's a violation of the open meeting law. You had a multi-way discussion amongst a quorum of your public body. Matter if you're giving facts versus opinions for whether you trigger the open meeting law? Probably not. Deliberation is one of the things that triggers the open meeting law, and if you look at a dictionary, deliberation includes an exchange of facts. So if you shoot a bunch of like stats and facts off on an issue to a board member and it reaches a quorum, and then another board member replies all back through, to your email with other facts or whatever, or their opinions, that's probably a meeting, and you probably violated the open meeting law. to consider putting it in your email signatures is a little reminder about the open meeting law, like the one on this slide. Basically, so you just always fire off this little reminder to be careful about who you're emailing and what you're emailing. It costs nothing and it's super easy to do. Yes, it'll be ignored 99% of the time, but at some point it probably has saved somebody and reminded somebody. So it might be worth considering something like this in your email signature for your board members. Staff can send emails and communications to board members without necessarily violating the open meeting law. Passively receiving information from staff in and of itself does not violate the open meeting law. So that's how we send out notices, agendas, supporting documentation for meetings, so on and so forth. I mentioned earlier, and it's now in the definition of the open meeting law, usually to violate the open meeting law, you need multi-way communication. So if I email my whole board and say, how's everybody thinking or leaning on this issue? What are your thoughts on this issue for the next meeting? If nobody replies, it's probably not an open meeting law violation because it wasn't a discussion. To have a discussion, you need 2 or more people talking. It wasn't deliberation. But the one exception to that, where a single person can violate the open meeting law by talking, is by proposing legal action. So if I email my whole board and say, hey, I want everybody to vote this way at the next meeting on this issue, even if nobody replies, because I proposed the legal action to a quorum, that constitutes a meeting and was probably a violation of the open meeting law. So be very careful about that. So then how do you propose an agenda item without violating the open meeting law? Well, the key is to propose the general issue for discussion without proposing the specific action you want taken by the board. What does that look like in practice? Here's an example. Imagine you're on a city council and one of the members sends an email to the rest of you saying, at the next meeting, let's discuss safety at First Street and Main Street. That's fine. That's close. That's a little too close for comfort, but it's not violating the open meeting law because you're not proposing a specific action you want taken at the meeting. You're only proposing an issue for discussion. But instead, imagine you email something along the lines of, at the next meeting, let's vote to install a crosswalk at First Street and Main Street. That's a specific action you've proposed that you want taken. So even if nobody replies, you violated the open meeting law. You went above and beyond just the general topic for the agenda and went to the action you want taken. Another example, say one of you emails the rest and says, hey, let's vote to fire the or consider firing the county manager at the next meeting. That's probably a violation of the open meeting law because you've proposed a particular legal action, firing someone. But if instead you say, hey, at the next meeting, let's put on the agenda that we'll discuss the city manager's work performance, that's probably fine. The action you want taken. It's going to a third person, and if you word it weird in a way that you wouldn't be able to communicate to the other members, clean it up a little and straighten it all out for you so you don't accidentally violate the open meeting law by going straight to each other. But if you insist on doing it, make sure you stick to only the issue and not the specific action you want taken. I'm going to skip the next couple examples. They're repetitive. The open meeting law, under the open meeting law, you can't knowingly direct staff to do something that you can't. So if I can't go to the other members and say, hey, vote this way at the next meeting, then I can't ask a staff member to do it. So I can't go to the clerk and say, hey, go tell them that Danny wants everybody to vote this way. That would be a violation on my part and on the staff member's part. So don't knowingly ask your staff to do things that are in violation of the open meeting law, and staff don't do things you know are in violation of the open meeting law. You can all be sanctioned if you do this. Again, the key is knowingly. So you have to know what you're doing is wrong and that you're doing it. So we make mistakes. Occasionally you might ask something that somebody goes, hey, that's a violation if we do that. And you go, oh, whoops, didn't realize it. Not the end of the world. But if you go, hey, yeah, I'm not allowed to do this, you go do this for me, that's a big deal. There's this weird little carve out exception in the open meeting law. Normally you can't discuss things that you know the other board members are going to hear, but there's an exception for when it's done in public in front of media. So say you're walking out of, say you're a Phoenix City Council member and you just had a really hot debate over mask mandates, and you're leaving after the meeting and you're walking down the stairs and a reporter shoves a microphone in your face and says, how are you going to vote on the mask mandate issue at the next meeting? You know the other members are probably going to hear what you have to say, but you can say it anyway. One, probably because of the First Amendment, and two, because the open meeting law has a carve out where you can discuss issues and express opinions at public venues other than your public meetings through the media or other public broadcasts, as long as you're not doing it intentionally to get around the open meeting law. So if you're intentionally seeking out a reporter who's going to bury your comments on the back page of a newspaper so nobody will really see it, but then you can tip off your other board members, that would be a violation. But if you're just answering questions or discussing things in front of a reporter, that's okay. The open meeting law says, when in doubt, resolve everything in favor of openness. So whoever's tasked with interpreting the open meeting law, like you guys, you have, when you have the gray areas, when you have the tough in between situations, you're supposed to resolve it in favor of openness and transparency. What's the big problem here that we're trying to avoid? Well, one, you could get in trouble, although that's pretty rare. But more likely, you run into a trouble, the trouble where your legal actions will be voided by a court. What does that mean? Well, legal action, again, is defined as any decision you guys make. So if you vote to spend $1,000, that's a legal action. You vote to fire somebody, legal action. Legal actions, when there are related violations of the open meeting law, can be rendered null and void by a judge. It has to be a serious related violation. So if during your meeting, somebody goes off agenda for 5 minutes with what they're talking about, and then you steer them back on topic and say, hey, that's not on the agenda, that's not going to ruin everything that happens at your whole meeting. But say it's more serious than that. You vote to spend $1,000 on a new park, and that wasn't on the agenda. That vote's probably null and void. Or you forgot to publish a notice and agenda for the meeting. That's super serious. That's probably going to wreck everything for the whole meeting. So any actions you take are going to be rendered null and void. So that's the big danger that can happen from committing open meeting law violations. You can vote on things and start taking actions that are actually going to be rendered null and void by a judge if push comes to shove. So what happens if you're in the middle of a meeting and you think you violated the open meeting law? Well, you can put the brakes on and recess the meeting and figure out if you can proceed without further violations. So is it a minor thing? Did somebody just start talking about something that wasn't on the agenda? Then just tell them, hey, that's not on the agenda, get back on topic. But did you realize halfway through the meeting that you forgot to publish a notice so the public doesn't even know the meeting is happening? Then you should probably cancel the meeting, because anything that happens from that point on will be in violation of the open meeting law. And then you now know it is, so you're knowingly violating it, which triggers more penalties. Again, depending on the open meeting law violation, it doesn't necessarily taint the whole meeting. It depends on how serious the violation is. So what happens if after the meeting you realize, oh, geez, we might have violated the open meeting law? Like after the meeting you forget, or you realize you forgot to post a notice and an agenda, or you told the public the wrong time, so no one was able to attend. Well, first, evaluate how bad or what the conduct was and if it was a violation. If so, get everyone on the same page as to why it was a violation and learn from it so you don't do it again. If you get complaints about it, I suggest being open and transparent about it. Get people the materials they need to realize what the violation was and how to fix it. And then last, figure out if you need to ratify it. Ratification is a process by which you have a null and void legal action due to an open meeting law violation. You can follow certain steps outlined in the law to basically bring that up to code. So even though it was a violation and the action's probably null and void, you can take steps after the fact to make that action legitimate. You could still theoretically get in trouble for having violated the open meeting law, but that action is now good. So how does that process work? It's laid out in the open meeting law, and basically within 30 days after the violation of the open meeting law, or 30 days after you should have found it, you can ratify. So what do? Basically, you have a public meeting and you explain you messed up and that you're ratifying the action. You need 72 hours of notice for one of these ratification processes instead of just the regular 24. You need a written description of the action that you're ratifying, a statement that you are ratifying a previous action, information on how the public can get their hands on these writings. The writings also need to be available 72 hours in advance. And again, they need to include the action being ratified, summaries of all the prior deliberations and everything that went into it. And then all that stuff must be included with the minutes or recording. Basically, if you get to a point where you think you need to ratify, I suggest contacting your legal counsel and just making sure you don't dig the hole any deeper. Last but not least, what can happen if you violate the open meeting law? How can you get penalized? Again, it's very, very rare for an individual to get penalized under the open meeting law. And why is that? Because not only do you have to violate the open meeting law, you have to do it independently. So you basically have, there has to be proof that you knew what you were doing was a violation of the open meeting law, and that you did it anyway. So if that happens, the Attorney General, and only the Attorney General, can take you to court, you as an individual member, and a judge can fine you up to $500 for the second violation and up to $2,500 for the third, fourth, and subsequent violations. The implication being that the first one's a freebie and you can't get fined for it. They can also assess you whatever other relief is equitable, which who knows what a judge will think is equitable, and attorney's fees, which, as you know, can get very expensive. So it can be very pricey if a judge finds that you knowingly violated the open meeting law. Your public body doesn't get to reimburse you for this. It's on you. So if you get fined $2,500 and then $3,000 for attorney's fees, it's coming out of your pocket. Again, super, super, super rare. You basically have to intentionally violate the open meeting law. The AG has to take you to court, and then they have to prove that you did this. This pretty much never happens unless you have a super shady, corrupt board. Innocent mistakes are not going to lead to this. There is a defense for this. So if you know what's happening is a violation, but you participate anyway, but you formally object on the record and say, hey, I think what you guys are trying to do is a violation of the open meeting law, but since you're doing it anyway, I'm going to participate. That way my vote's counted. If then you're taken to court by the AG over that, you can use your objection as a defense, and hopefully the judge will side with you. The last penalty, if you're found by a judge not only to have knowingly violated, but also with intent to deprive the public of information, you can be removed from office by the court. So if you intentionally violate the open meeting law to hide stuff from the public, a judge can throw you out of office and you can potentially be charged with a crime. So don't be a corrupt jerk, is the moral of the story. And then this last slide is some resources on the open meeting law, but I feel the need to bring you up to speed on a currently pending bill. There is a bill before the legislature. It's already passed, I believe, the House, and it's before the Senate. It will modify the executive sessions in the open meeting law so that if you're going to get legal advice, it can't be on any topic under the sun. It can only be on a topic that is related to one of the other 8 types of executive session. So in my opinion, it's going to dramatically curtail attorney-client privilege for public bodies, because if it doesn't fit into a negotiation or litigation or something like that, it can't be done in executive session. So if that troubles you, you might want to get to your representatives at the state legislature to lobby against it. It passed the House, I want to say 31-29, and it's been sitting in the Senate for a couple weeks. It hasn't been scheduled for anything past second read, so I'm wondering if it's going to die there, but who knows. So just know that that bill is out there. I don't have the number off the top of my head, but if that's something you're interested in and you can't find it, shoot me an email and I'll send you the bill number. Otherwise, our website has a whole bunch of good materials, including our agency's handbook on the open meeting law. I suggest you bookmark that or print it out, or email me if you want a hard copy. And that's it. If you have any questions, let me know. If you think of any questions or issues come up later that you want to bounce off somebody, feel free to give us a call or shoot me an email, and I'll be happy to give you the best answer I got on what the open meeting law says. Any questions?
Mr. Garone, I have a couple.
We have some participants who'd like to ask questions, so I think we'll use the forum of hands up, and of course we'll let the board go first. So, Mr. Crosby, did you have your hand up?
Yes, indeed. Mr. Garone, referring to slide number 13, I was wondering if there is any statutory requirement of having an odd numbered board. And then I have two more questions after that.
I'm not aware of any requirement that you have an odd numbered board. I know there are even numbered boards. And so say you got 8 members, the quorum is 5. But like I'm sure you know, having an even number can create all sorts of trouble. So I'd probably recommend an odd numbered board, but I don't think there's anything in law that restricts it.
Okay, referring to slides 36 through 43 about executive session, I believe that attorney-client privilege and executive session should be a matter for the board to decide. Is there any exceptions to that where the county attorney would decide this has to be in executive session, or the board's attorney would decide that this has to be an executive session?
Well, ultimately, my understanding of how the government is set up is the attorney is your attorney. They're not your boss. So they can tell you, hey, the law requires this, and you're free to disagree or disregard that advice. Will you run into trouble if you do that? Potentially. But you're the ones elected to do the job.
Okay, can you give, how about a hypothetical situation, if I might trouble you for that? In what type of hypothetical situation can you imagine that it would be a problem?
Where what would be a problem?
The board deciding not to have an executive session which is against the attorney's advice.
So if the attorney says, hey, I think this executive session will be illegal, and you do it anyway, and then somebody complains to the attorney general and the attorney general agrees that it was illegal, then you can get in trouble. And then there'll be evidence to show that you knew it was wrong. So you could get in more trouble from it.
Actually, I was thinking of it the other way around, but that's okay. Let's move on to slide number 45, which was a specific example of school safety in the first instance, or the top of the slide, and then the general broader parameter of safety. And what I'm thinking of is for a hypothetical rash of car burglaries, for instance, and the board wants to know, for instance, from the sheriff, how is the sheriff going to handle this rash of car burglaries? And so I believe that from what you said, that could be a situation where the board could ask the sheriff to come in and interview the sheriff under an executive session. Is that correct? Or should I describe it more in detail?
I honestly don't know with certainty. You know, this is new. It hasn't been fleshed out by the courts. I don't know exactly what the legislature had in mind, but I think you could make a reasonably defensible argument. So say your building you're worried it's open to a crazy guy with a gun coming in, and you want to bring in the sheriff and say, okay, what's your plan for keeping us all from getting shot in the building? And you don't want all the public to hear the plan. I think you could make a reasonable argument that you can have that guy from the sheriff's office with you in executive session to hash it out. Because the statute says with designated representatives, and the statute also says whoever's presence is reasonably necessary. And I think you could definitely argue that he's either a designated representative and or reasonably necessary to carry this out.
Okay, I agree with that. And I would add that since I did have a background as a union representative and frequently ran into issues where the person representing the head honcho was not the decision maker, that I believe that it would have to be the head honcho, whoever's in charge as a decision maker. But hey, that's just my opinion. That's all the questions I have. Thank you, Mr. Goro.
Okay, do we have other hands? I can't see from here, but I believe that there are.
I have a couple questions.
Okay,
Mr. Chairman, I have a question as well.
Okay, Ms. Judd, go ahead.
Thank you. It's when I was confused. There was a time when he said, you know, you go into executive session and you talk to your attorneys and or other individuals in your executive session, and then you decide that you're going to what you're going to do, and you have to come out before you discuss what you're going to do. Is that true, or do you discuss what you're going to do in there and then you come out and just say, okay, we're going to just do this? Because it sounded like the discussion had to happen in open session.
So if, say you have a legal question like, if we take action A, are we violating the law? You can go into executive session with your lawyer and say, hey, attorney, we want to take action or potentially take action A. What are the legal ramifications if we do that? Is it illegal? Then the attorney can turn around and say, here's my legal thoughts on that. I think it would be illegal for these reasons, or I think it wouldn't be, or blah, blah, blah. And then you can follow up and say, so what will happen to us if we do that from a legal perspective? Will we be on the hook for fines? Will we get sued? Blah, blah, blah. Then once that's all over, the three board members think to themselves, okay, do we want to take that action in light of what we just heard? That discussion then must take place in a different type of executive session or in public. So you got the legal advice. Now you want to decide what to do with the legal advice. Do we want to listen to the lawyer? Do we want to disregard the lawyer? Do we want to do something totally different? That has to take place in a different type of executive session or out in public.
So what would that transition look like to that different kind of executive session?
Well, it would have to fit neatly into one of the other types. So you'd probably say it was firing somebody, because that's something you can talk about in executive session. So maybe you have an agenda that says we're going to go into executive session to discuss the employment of the county manager and to seek legal advice on the issue. So it's a 2-for-1. So you can go into executive session and say, hey, attorney, are we going to get sued under blah, blah, blah if we fire this guy for this reason? Then the attorney says yes or no, or maybe. Then, because it fits into the other type of executive session, you can then discuss whether to fire the guy. That's an example of where you could do it in a different type of executive session. But as a different example, say you want to know, hey, attorney, if we spend money on this issue, is that legal? The lawyer tells you in executive session, and then you have to decide whether to still spend that money. That's not going to fit into a different type of executive session. So if you want to have that discussion about what to do with that legal advice and whether to spend that money, that has to be done in public.
Okay, thank you.
Okay, I think we have some members of the public with questions, but usually they're members of special districts or a body that might be having to follow the open meeting law. So I see one from Stephen Day. I may have a question.
Yeah, and I'm actually a member of two bodies. Bisbee Streets and Infrastructure Committee, and I just got elected to the Naco Sanitary District, and it has directly related to creating agendas. And because of the small nature of our thing or whatever, it's like to hire a third person to run the agenda items to the chairperson who creates the agenda. My question is, if I have a question, or if I have an agenda on it, can I just, because it was suggested at the Bisbee's committee that we all send our ideas for agenda items directly to the chairman, who is also a member of that board. So if more than a quorum of members decides to send suggestions for an agenda item directly to the chairperson, is that chairperson in violation of open meeting law, or is it okay to do that? Because I asked that question there. Is it okay for us to actually do it this way, or should we consider having a third person?
How many
and for
people
the same
are?
reason, not the sanitary district, that we would actually have to hire a third person in order to do it if it was necessary.
If there are more than, say, if there are 5 or more people on the board, or I take it back, if there are 4 or more people on the board, then if your quorum's going to be 3 or higher. So if you are only emailing one other member what you want on the agenda, even if you phrase it poorly, you phrase it as proposing legal action, it hasn't reached a quorum, you're not violating the open meeting law. So that's probably why it's been recommended that you all send it to one person. Because if instead,
yeah, because one's a 7-member and one's a 5-member, yeah.
So where you run into trouble is if you have a 3-member board, because designating that one person, you're still going to have 2 people talking. So if you all, the other 2 members send it to the chair, even though it's just going to one other guy, you're potentially violating the open meeting law if you accidentally propose legal action. So on bigger boards, that's a good solution. On a smaller board, you still got to be extra careful.
Okay, so basically, as long as we don't reply all, or I just send it to him and he doesn't send any of that information to anyone else, and we're all gonna be compliant. Okay, that's the point I needed to know. Thank you very much.
You're welcome.
Do we have other hands that are up? I know the county administrator has some questions he'd like to have clarified. If there's no other hands up or people that have unmuted. Okay, Rich, go ahead.
A couple of questions. So during a board meeting, the example that you use is that someone's going off topic and there's someone say, hey, I think you're getting to the open meeting law, you're going off topic. How should that happen? Should it just be mentioned that, hey, I believe you're going in another direction, and then that conversation stops?
Yeah, so say your board's at a meeting and your board's only meeting about the budget. And then for some reason, one of the board members just goes off on a tangent for 10, starts going on and on about why they want to fire one of their employees. That's not something they're allowed to talk about because it's not on the agenda. So how you handle that is really up to your body. Maybe you want your chair to handle that and say, okay, that's not on the agenda. We can't discuss that. It'll be an open meeting law violation. So we're going to have to move away from that topic back to what's on the agenda. If they just refuse and they just go rogue, there's not a lot you can do about it because, they're an individual person who, sometimes you have a board who with a bad dynamic and board members won't listen and they do things that are violations even if no one is okay with it. So in those situations, I don't really have a lot of advice, but normally what I would suggest is just kindly remind them that it's not on the agenda and can't be talked about and steer them back on topic.
And you also mentioned there's a current events, right? So if you notice current events, that seems a very broad topic.
Yes.
So is it broad in nature or are there parameters to it that you know?
It's not really fleshed out in the law. So the way I envision it is the agenda would say something like board member Derone will provide a brief summary of current events. And then I stand up and say whatever the few things are. And then nobody else gets to talk about those things. So how specific do they have to be that I'm talking about, or can I just go up there and basically give long speeches about whatever I want? I think it's meant more to be about specific things, like, hey, don't forget the deadline for this is coming up, and we need to get X, Y done by Friday in order to meet the federal, deadline to get our money request in, blah, 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 and that type of stuff. And so-and-so's last day is Friday and things like that. But should I be able to get up there and give a 20-minute stem winder on why we should fire the county manager? No, that's probably not what was intended by that provision.
So it's mostly factual, not opinion?
That's the way I read it. Would another lawyer disagree with me? Maybe, but that's the way I've always read it. It's more just like a presentation of a bunch of short stuff that really doesn't necessitate being its own agenda items for discussion.
Okay, and so as we're in this new weird age of technology and we have Teams meetings for board meetings, if board members, can they text, email, call someone during those board meetings? And should that be part of public record if they do?
So let me make sure I understand. So say the board of supervisors is meeting, can the board call somebody and put them on speakerphone to talk at the meeting?
No, individually. Individually, can someone call someone? Can someone text someone? Can we email someone while during a board meeting?
You mean other board members?
No, just anyone.
Oh, so you just, while somebody else is talking at the meeting, can you be emailing your mom about Mother's Day plans?
Right.
Yeah, that's not an open meeting law violation. The other members might find it rude if they figure out it's happening, but you could do that during a regular meeting. You can have the Jimmy John's guy walk into your meeting and interrupt it without violating the open meeting law, but it's its own problem.
But can I have an email to someone that's on topic, but it's not being addressed in an open meeting?
If you're talking to just non-members of the public body, you can basically do whatever you want.
Okay.
So if you want to private during a meeting, like say right now, you're a board member and you're at the same time you want to email like your mom about whatever's being discussed at the meeting, you can do that. But if you want to discuss it with any of the other board members, it needs to be done so that everybody can hear it.
And my last question, thank you for answering all my questions. So social events. So if you notice a social event and 2 or 3 of the board members are going to the same social event, but one's speaking at that social event.
Yes.
So what happens when that board member who obviously is speaking is obviously, you will be giving opinions about possible votes.
Right.
So what happens at that occasion?
This comes up a lot with conferences. I know there's at least one organization that does conferences for the county boards of supervisors, and so all the supervisors show up. You got to be careful. So if some like specific items come up that then could come before your board for action, you got to be careful about what you say in front of your other board members and what they then say. So if say there's a breakout session and 2 of your 3 board members end up at the same breakout session, and it's talking about like ideas on how to handle the coronavirus within your county, you probably can't legally talk about it if you have a 3-person board with 2 of your board members there. It seems annoying and obnoxious, but if you read the open meeting law, that's probably how it works. So there are a couple solutions. 1, send fewer members than a quorum to these events. If you must have a quorum present, then be careful and either don't talk in front of each other or be very careful about what you say. It's especially for the smaller boards, the 3-person boards, very, very slippery because you only need one other person to hear some of the things you might propose to create a violation.
That's all the questions I have.
Do you see any other hands up or anyone who has unmuted? I think Mr. Crosby has a hands up right now.
Hey, there you go. Thank you, Madam Chair. Going off of what Mr. Karwachka said about possible meetings, if I go to a political meeting where I know I am going to be a speaker, then it could be noticed or not as a time when a quorum might be present. But another situation is if that meeting is public or not, and that could change in the middle of a meeting based on what the chairman of that meeting says. I'm talking about like a political party meeting. The meeting basically is public as long as nobody is disruptive, like some member of the public came in there purposely to disrupt. And so the chairman of that meeting would say, Joe Smith, you got to leave. This is no longer public. Okay. And at that time, because it is no longer a public meeting, whether it's noticed or not, it doesn't matter. And if 2 people are there on this board, then that would constitute an open meeting law violation, I believe, if I were to speak about board business, which I would. Any comments on that, Mr. Garon?
I think you're right. I think if you're at an event and you're treating it like an open meeting, so you want to be able to talk and there's a quorum present and you did a notice agenda and the public can show up, and then suddenly for reasons outside of your control it's no longer public, then you need, or even if there are reasons within your control, if it's no longer public, then the discussion and the proposing legal action need to stop. If you continue onward at a non-public event, then you're going to be violating the open meeting law.
Okay, in that case, just we're talking about a hypothetical situation. What if it stays public? There is nobody that disrupts and it stays public and it is noticed, then what? Or should we just err on the side of caution, or what do you think?
So imagine you're going to a conference of county supervisors and you want to be able to have, the agenda ahead of time, and there's a topic your whole board wants to be able to weigh in on. You'll have the discussion and you'll hear it. That's going to be a meeting. It's going to trigger the open meeting law. That's okay if you put out a notice, you put out an agenda, and the public's allowed to show up for free. So if the public, you go through all that rigmarole and the public shows up and hears you guys, that's fine. And if it stays public, that's fine. If it turns private, you either need to leave or stop talking to not violate the open meeting law.
Okay, in that case, if it does stay public, then 2 or more of us can stay at the same meeting and talk about county business if it was noticed.
As long as the public's allowed to attend and the notice and agenda you put out are accurate to what's being discussed.
Okay, thank you. No more questions. Thank you, Madam Chair.
Okay, is there anyone else that you see? There's a red dot by some, but I'm not sure what that means.
That's just us. That's okay.
Anyone else? I guess I also want to echo what the county administrator said. We're very grateful, Mr. Garone, that you were able to be with us today and to bring this information to us. We all need reminding of the open meeting law, even though we participate in it all the time. It's very refreshing to get it back and see it in writing again. So thank you in your position as the ombudsman for being willing to, and I know you probably would have come down to visit with us because people like to come to Cochise County to visit, but if we hadn't had the coronavirus, we would have been glad to host you, but online is better than not at all. So I really want to thank you for participating. Is there anyone else that has any comments before I close this meeting? The one thing I would like to say is to tell you when the next board meeting will be, and that will be April the 6th at 10 a.m. Board of Supervisors meeting 10 o'clock. So with no other information, this meeting is adjourned.